matter pertains to land acquisition in 1962 and the compensation awarded in 1970. And the issue pending here is just about the quantum of compensation. However, we are from the respondents and I'm 60 years old. So I request it may be listed at any earliest date.
Already listed on 21st of February, not to be detailed.
My lords, unlisted mentioning, this pertains to MBBS admission NRI quota. The counselling is getting over tomorrow. The High Court directs giving admission to a student who has forged documents. So I'm praying for listing tomorrow, my lords.
What is not possible?
My lords, day after.
Monday.
My lords, counselling.
We can't help now. We are with so many matters. So
Understand, my lords.
matters.
My lords, day after, if my lords, the counselling will get over. Otherwise, there are 600 students, NRI students waiting for admission. Otherwise, my lords.
Friday.
Obliged.
With my lord's permission.
Also.
With my lord's permission, may I please mention SLP number 20566, my lords. The matter pertains to NEET undergraduate admission process, my lords. The petition.
Number?
SLP number 20566, my lord. The matter pertains to NEET undergraduate admission process for 2025 academic year, my lord. The petitioner is a domicile and a resident of state of Goa. Your lordship have issued notice on 30th of July, returnable within 1 week. I'm only requesting for not to be deleted from 12th of August, my lords.
With my lord's
Not to
permission,
be deleted.
My lords, I'm so sorry. I understand Friday is a holiday. My lords, Thursday in that.
with my lord's
That's why
permission,
mentioning is allowed.
mention.
There has to be some order in which the yes, we start from there. So this
My lord, may I mention item SLP Civil 15526 of 2024. Lordship, the matter was supposed to be listed today. I had mentioned the matter, but the matter is not listed. The matter was lastly listed before Justice. It is about the property matter, Lordship. This matter is listed before the execution court on the 13th, Lordship. However, the adjournment letter has been rejected by the court. On the last occasion, the matter was adjourned before the execution court only because the matter was pending before the Supreme Court, Lordship. But matter has not been listed since 4 months. Lordship may kindly consider it and keep it tomorrow, Lordship.
or how many matters we can take? How many?
It was listed before Justice Bella Trivedi and Justice
To
Vada.
some other thing.
Tomorrow?
Yes.
Much obliged, Lordship.
May I mention that Judpi Jungle judgment, Lordship had passed on 22nd of May. We have filed a application for modification of a judgment. I am requesting Lordship.
Modification or clarification?
Lordship.
Modification or clarification?
Clarification, Lordship. Clarification, Lordship. I am requesting it will be kept on Thursday. A small application.
Not on Thursday, Friday. I think Thursday को तो पूरा दिन बैठना है.
वहाँ से.
Lordships issued notice in this matter in last 2024 November, returnable in 3 weeks, my lord, but it has not listed till date, my lord.
What is it about?
It's, my lord, regarding right to health, to include the Ayush in the Ayushman Bharat scheme, my lord.
CB के बाद. Yes.
Your Lordship, High Court.
Let him actually. Are you also mentioning this one? You are also mentioning?
Yes, my Lord. Your Lordship.
Let it be in the queue, yes.
My lords, if I may mention diary number 44549, this is a fresh SLP coming from Karnataka regarding the detention of a foreign national. He has already been granted bail by the High Court, but on the same day he has been picked up by the detention center.
Very good.
For SLPs on behalf of NHAI, Your Lordship, toll collection has been suspended by the Honorable Kerala High Court, which is costing me 50 lakhs per day, my lord. So,
On what ground?
on some statutory mandate not being followed by me, my lords, I request for the matters to be listed tomorrow, my lords.
Not tomorrow. Thursday.
My lords, I have also done the formal procedure of mentioning, my lords. My lords, because every day,
Thursday we are saying it.
my lords,
Yes.
I'm grateful.
Yes, please give way to the next council, madam.
Your Lordship, the Honorable Madras High Court had regularized the seats of Group D employees, my lord, against the unsanctioned post, my lord. In the contempt petition, which is coming up tomorrow, the Registrar of University has been called in person, my lord. It is contempt listed tomorrow, my lords.
So let him come. He has been called, let him come.
Lord, the seats has been regularized against the unsanctioned post, my lord. That's why seeking for listing tomorrow, my lord. My lord, it was even mentioned on Friday, my lord, for listing today, but it didn't come up, my lord.
He has been directed by which court to come?
My lord, this honorable court.
But they'll let him come because there must be something why the court has passed the order for direction. Otherwise, normally we don't direct. Have it on Friday, Thursday.
Thursday. Thank you.
My lord, I am mentioning on.
Yes, Mr. Everett.
First, may I mention a matter? It's a matrimonial dispute. It's shown for 18th of 8th of this month. But the bench for which it was listed was Justice Bela Trivedi and Satish Sharma. I'm requesting for a listing on 18th on before and after bench.
Yes.
My lord, I'm mentioning for you on writ petition. My lord, need to urgency Thursday or Monday. My lord, the matter is, my lord, the matter is, the one of the in Gujarat, one of the Vanandar one institute in the Gujarat. Vandar. They taken away entire temple elephant, then forcibly taken away. My lord.
Thursday.
Lordships,
Yes,
mentioning a matter that was listed on Friday for clubbing of FIRs, Lordships have issued notice and tagged with the matter mentioned in the office report. I had also prayed for no coercive steps. The matter in the office report didn't have that or direction because he is still in jail, but co-accused has been granted that order of no coercive steps.
But what, you have already.
Have it on Tuesday, so your Lordships has the paper book before Lordships have
Monday.
Monday. Great.
Yes.
Lordships, Lordships, he is going to be released today. He has been granted bail only on 7th. Could your Lordships have it anytime this week? Otherwise, he'll get arrested again in the meanwhile.
Thursday.
Thursday, great.
My lord's petitioner is an army personnel. He's been involved in an old 304B case. Notice was issued in the main SLP. We were asked to surrender. He has duly surrendered. He's a part of Operation Sindoor and a trained commando. We have filed an application for bail. My lords, his family is suffering. My only request is that the matter may be taken up this week, my lords.
Thursday. Yes, Mr.
Please, with my lord's permission, may I mention writ petition 783 of 24, my lords, this matter had been wrongly tagged along with those Telangana medical admission matters. On that day also, I had sought for detagging, my lords had ordered it, but it's not reflected in the order. I'm only seeking detagging, my lords, because this matter pertains to Andhra and has nothing to do with those matters.
Detectives.
Obliged, my lords.
You don't want to be covered by that judgment.
Please, my lords, we don't want any complications. Obliged.
Yes. Item 1 is an application seeking modification of your lordship's earlier order, my lords. Lordships in 2022 are disposing of, my lords.
What is the stage of the trial?
My lords, this is the last order I have of the.
What is the stage of the trial?
Only one witness has been examined, but others have been.
3 weeks. So the state conflict.
I'll serve the stand.
Come for unto bail, my lords, in matter where, my lords, the trial court had convicted me, the High Court had acquitted me in the first round by well-reasoned order. The lordships demanded the matter back, after which, my lords, the High Court has convicted me. Now, my lords, in the impugned order, there is not a whisper of discussion about the submissions.
Take the book of traditions, make a pyre of cliches, and burn it.
The smoke that emerges is
Here the appeal itself on merit.
Some short date then, my lords.
Yes, on some Monday or Friday.
Very well, my lords. Monday or Friday.
Friday, after Monday.
Very, very. Well, it's all on an NMD.
Well, Buddha has been kind enough to
Have read the papers.
on Mondays and Fridays in the second week to take up old well matters.
Milords, the
Very
trial
good.
court, records has to be sought for in this, Milords, because they are not on record.
Maybe what you have the relevant evidence.
I'm sorry, my lords.
We have the relevant evidence.
We have the relevant evidence.
They have not annexed, Milords, any
My lords,
of
it's,
the,
my lords, the trial court record will have to be called.
it
But I'm
has to
stand
be
aside
called,
because
Milords. They
it's
have not
19
annexed anything.
1994.
Call for RNP.
Milords, may I have it on, in the month of October, September, Milords?
Call for RNP expedition.
Because translation, because it would be in Punjabi, so translation would also be required in that.
Yes.
99. Grateful.
Obliged, Milords.
He's going to complete 3 years in behind the bar and no charge sheet, sorry, no witness has been examined and not even the summoning has been done. And there's no previous conviction.
Any
There are no antecedents, but it is a commercial quantity for.
No, hardly 68. 50 is the
69, so it is a commercial quantity. If you are saying hardly,
little bit above the 50.
not little by now, it is 19.81 grams
Yes.
above.
No.
You are saying little bit.
Commercial quantity for trafficking.
Because
my
3
lord.
years,
My lords have
3 years
taken a
ago,
very.
because he is behind the bar, no trial at all.
Yeah, no, okay. Vehemently opposed by the learned case before the state on the ground that the petitioner has been caught red-handed with contraband. He is of a commercial quantity. Very good. Correct, the petitioner said that the trial is not progressing very. Only one witness has been in.
No witness.
Not a single witness has been examined so far. As we already observed in so many matters, that prolonged incarceration cannot be permitted to be sentenced without trial. That we have submitted, we are inclined to allow the.
Obliged.
Yes.
Yes, ma'am. But there's a liberty granted by this court to reapproach if the trial is not commenced within the period of 6 months by order dated 18th November 2024. But the petitioner has no antecedents, my lord. He is behind the bars since 3 years, 4 months. And my lord, for right from the period when the liberty is granted, my lord, for about 8 months, the matter was only kept for deposition of muddemal. About 14 dates, and with a gap of 20 to 30 days between each adjournment dates, which is again the procedural rule of adjournment also in custody matters. But there's no progress in trial. In fact, it's kept for deposition of muddemal on 15 days. And there's a minor son also who is dependent on him. 3.5 years, he's behind the bars.
Minor son is staying with you or with the grandparents?
No, right now he's in his family's custody.
With
His family's custody.
your family's custody?
Yes.
Yes.
Now, your lordships, at the very outset, I would like to submit that this trial is at the stage of evidence. Now, it will be relevant to look at the conduct of the accused and his advocate during the course of trial. Now, your lordships may kindly look at the deposition.
Last 2 dates, I would like to point out, last 2 days.
And also, your lordships?
Only on the last 2 days, his advocate was unwell, so he withdrew wakalatnama on the last date. And now they've engaged another advocate. But other 15, 16 dates, it's only
In the
kept
middle of the trial, they have his advocate has withdrawn his wakalatnama.
Yes, my lord, because he was unwell.
They are only
But the
prolonging the
liberty
trial.
accrued.
Your lordships, they cannot be
The
allowed
liberty
to take
accrued.
advantage.
1 minute. The other side also has. Let us complete.
The liberty accrued on the very day, 18th November 2025, and 20th May 2025, notice was issued by this court. But they have started the trial only after issuance of notice by this court and after filing of this SLP. Only on the last date, PW1 was being examined, and now they have engaged another lawyer for the trials. Only on that last date, the lawyer did not appear because he was unwell, and they've engaged another lawyer. Otherwise, on 15 days, the matter has been only kept for deposition of muddemal. And my lord, even as per the allegation, my lord, this is the case of.
No, but you go to the complainant's house, you stab the brother of the complainant. He is running, you follow him in the shop.
Here, even at the most, the allegations that
Yes,
he is the father.
Suppose even if you are, for some reason, convicted under part 1.
Yes.
Not under 302. Still, for part 1, it will be 10 years.
10 years.
Part 1, normally it will be 10 years.
But he's already undergone 3.5.
And half. So
During the
it doesn't come to even half of that.
During the pendency of trial, no trial has also not progressed. And there was an order of this court. And there was an order of this court.
Not inclined to entertain
Within a period of 6 months, my lord had granted liberty, and my lord, there was no progress in trial in the last 6 months. So, page 103, if my lord will see, my lord.
If you want an order of expedition, permit us to dictate the order, otherwise we'll dismiss it outright.
Because my lord had not expeditious, my lord.
We are not inclined to enter in the prison application. However, in the practice of the circuit, we are inclined to direct the learned trial judge to decide the trial, to conclude the trial expedition.
Yes.
As precious as possible, and in any case, within a period of 1 year from today. needless to say that, like, shall cooperate with the expedition disposal of the trial.
May I
Publish.
request for 6 months, my lord?
Within a period of 2 years.
No, no, I apologize, my lord. I apologize.
Publish.
Yes, our court masters know what this is.
Obliged. Sir, if my request for liberty to approach this court, may I request liberty to
Now
reapproach?
the learned trial will conclude within 1 year.
If it doesn't conclude, my
The direction states. As requested.
Please, Your Lordship. Here, my lord, the High Court has found 3 questions and responses to be suspect incorrect. We do not dispute that. The High Court expert committee of the High Court on the administrative side
Question number 8. So what is the model key answer?
the question number 8, my lords, the model, all these answers were approved by the
No. We are asking you what was the model answer?
model answer said it is to be B, more than one boy were present from the class.
Wrong.
Yes, that is wrong. I don't dispute that. We are not here to dispute that, my lords.
I could.
Was right in saying that A should have been the answer. I am not disputing that. But here what the High Court goes further is that it says for one question you do re-evaluation and then evolves the formula for marking, for making out the cutoff marks, my lords. Published, your lordship.
8 weeks. Stay of the MP order.
Lords, I'm a 21-year-old medical ass.
Bringing the directive to the Supreme Court.
Lord, there is an identical matter against the same parties which has already been
In
to notice.
the judgment which we have delivered, arose from the judgment of the High Court, authored by my learned brother.
Please, my lord. My lords, the decision of this
Why
honorable.
don't you go to the High Court? High Court is bound by our decision now.
Lords, I can go to the High Court. My lords, the difficulty is that there is already a writ petition which is pending before this honorable court against the same parties on the same issue.
No,
My
no.
batchmate.
We have decided the matter in the case of Vansh and Onkar,
Yes, my lords.
and that is arising out of the judgment of the High Court.
Please, my lords. My lords, there is a writ petition which for my
We have to
batchmate
go
has
to
been
the
filed
High
before
Court.
this
That can
honorable.
be a ground, in the Supreme Court, that can be a ground to entertain a petition directly under 32.
Lords, I understand, my lords, but the grave difficulty is that the second round of counseling is
No,
happening.
go tomorrow.
Lords, and 1 year has already passed.
Which is the High Court.
My lords, it's going to be Patna High Court.
Go before Patna High Court.
Because I can go to Patna, my lords, there is no difficulty, but the difficulty is that there is serious infringement of my fundamental
If
rights.
we are aware about that, then we'll have to stop, close all the High Courts, put a lock on all the High
The
Courts.
issue is already pending before my lords.
It is not pending, it is concluded by us.
No, my lords, there is an issue which is.
There may be a writ petition pending, but the issue with regard to disability pension has been decided by a bench twice. Once we sitting with Justice Vishwanathan and once we sitting with Justice Sandeep Mehta.
Absolutely, my lords. I bow down. My lords, the only,
Therefore, those judgments are bound upon the High Court now.
yes,
If that petition comes up before, we'll relegate them to the High Court.
my lords, considering the same batch,
We are
same
thinking of
examination.
dismissing-
I understand, my lords. I'm bow down. My only last humble submission would be that my batchmates' issue is pending before my lords.
We'll relegate them to the High Court. Which is that matter? Give us number of that matter. We'll thank you for. Yes, give the number.
Please, assist.
Once there is a decision by this court, the High Courts are bound by that.
Certainly, my lords.
We'll list it the Lagal and Chaudhary. Send them also. So what do you want to withdraw? Should we?
My lords, I can withdraw and go to High Court if that liberty be granted, my lords.
Be granted.
Because in several cases, Dr. Satyendra has also been appointed by my lords in Anmol and other cases, and a complete assessment has been done, basis which the admission has been granted to various students with suffering from
We
disability.
have also entertained the petitions arising out of the High Court judgment. So are the High Courts not entitled under Article 226?
Then I'll come back, my lords. My lords may just give me that liberty, my lords.
Petitioner takes liberty to withdraw the petition with liberty to approach the jurisdictional High Court. But the liberty granted, since the matter pertains to the medical admission of physically disabled person, we request the High Court take up the matter expedition.
I'm so grateful.
If fine. If fine.
Please, my lords.
My lords had issued notice in a connected application under section 11, my lords. These are arising out of 3 EPC contracts.
Notice.
Maybe
Give the number of connected matters. Act.
Item 11, the petition, section 11 petition was not maintained
First was withdrawn without liberty,
without liberty. And second,
and second one was
allowed, your lordship.
Yes.
I'm challenging the second one was not maintainable for more than one reason.
returnable.
No.
Six.
Listen,
Stay of them around.
I'm praying for stay on the arbitration proceedings also because the arbitration has commenced. The arbitration
Well,
past section.
Once the open order is paid,
I didn't hear that. I apologize. Apologize.
Some more reasonable time, my lord. I am
What
paying
reasonable
rent, my
time?
lord, regularly. I am paying rent, my lord. Only this source of income is with me, my lord.
Now we will issue a contempt notice to you.
No, my lord, we.
One year was more than enough. Normally in residential premises, we grant only 3 weeks.
Lordship has kindly gracious to grant me, my lord, 6 months time, my lord. That was there, my lord. 6 months already, your lordship has granted me, my lord.
Now you want till March 26.
No, my lord, some reasonable time, my lord. My lord, this is the only source of income with me, my lord. And the only shop, my lord.
What about the landlord?
No, my lord, he has to give it on rent, my lord. I am regularly paying the rent, my lord. I am not saying anything, my lord. I will, my lord, vacate, my lord, before the time your lordship granted me time, my lord. And I am ready to, my lord.
Issue notice, returnable 4 weeks. Sir,
My lord, since time is expiring.
you are hearing the others are out here, we pass an order. It is a dispose of matter.
My lord, then I will be in contempt, my lord.
Maybe.
My lord, your lordship may protect me. My lord, I am not saying anything, my lord.
Sorry.
For the next date, my lord.
Dismiss.
My lord, your lordship may just protect me, my lord. For the meanwhile, my lord, I am not saying anything, my lord. I am not saying anything, my lord.
Dismissed. How can we, without the issuance of their notice on an undertaking, a matter is disposed?
My lord, I have
You have given an
that
undertaking.
because I have to vacate it by today, my
You
lord.
have given an undertaking, you have to abide by that. You
Yes,
should
my
have come,
lord, but that's why I moved this.
you should have come earlier.
I was moved, my lord, but it was showing, my lord, the before 8th showing, my lord, but now it is posted today, my lord.
You should have come at least 2 months earlier.
We filed on 22nd, my lord. We filed 22nd, my lord.
Only issue notice. Okay.
Please, highly obliged.
Because this is the matter
Whether
where
the High Court of Allahabad is not working.
yes,
Whether the High Court of Allahabad is closed.
it's actually Lucknow that is the competent authority, but Milords,
So,
the only reason
But
Milords,
Lucknow also has a bench, so whether the Lucknow bench has
Milords,
stopped.
the only reason that he is getting severe threats even after the filing the complaint before the DM and the CJM. The only reason was this. I am seeking liberty to withdraw the petition. I can withdraw the petition and go.
No, because I could, the learned complaint petition,
Unlike-
they were to withdraw it. But they approach the jurisdiction. By the court. Extended as requested.
May I please, Malas? Malas, this is a case where there are two agreements for us. The mother agreement provides for appointment of arbitrator. The tribunal of three, where in terms of the provision that New Delhi is going to be the seat and venue. That's a mother agreement, admitted position. And
It's in Delhi.
It's in Delhi.
Venue?
And whereas in the joint operation agreement, which was signed in 1995, is Kuala Lumpur, Malas. Now, the position is very clear that so far as the original agreement when it was signed, the production sharing contract, the terms were Kuala Lumpur, and that position was ad item in 90 because this agreement is, I hold 21% of participation interest in this. This went on till the extension was not there because this contract was for 25 years. In 2019, when the extension agreement came in, by that the time Union of India's policy came in, the extension is to be granted with certain terms, and one of the terms was the seat is going to be Delhi. That position was adopted and the amendment was made in the mother agreement, post 2019. So the position emerged that pre-2019 position is admitted that the clauses of Kuala Lumpur were retained. Post 2019, New Delhi was declared as a seat. That's the position is clear. So far as a joint development agreement is concerned, that was immediately signed post in 2005. There was the ad item, the provisions were there in 1995. That item provisions were there was that the Kuala Lumpur will remain. Now, there was a clause in that agreement specifically saying in event of conflict, the production sharing contract will prevail. That position is very clear from the contract. Today, I am holding a 21% interest in that. The joint operation agreement was signed for very limited purpose that the oil fields which are to be operated, those oil fields are particular to be dealt with in a particular, and scope was given that if anything in relation to operation of the oil field will come between the four companies, that is the only aspect to be seen. This was not dehorse of the principal agreement. And rather, I'll show from the clauses of the joint operation agreement, this was dependent on the principal agreement because the terms of the principal agreement was not deviated or modified. Let me show 2-3 things in this, Manoj. And the one more aspect, in the first agreement, Government of India was participating in the agreement, whereas the joint operation agreement, only 4 participating companies were there. This agreement, the production share agreement is page 81. If my lords can kindly come to page 81. And specifically, the parties are given at page 85. And if my lords may kindly note at 85, first is the President of India, second is the ONGC, third is Volco, which is Hardy today, fourth is IM, Hindustan, and fifth is the Tata Petrodyne. These were the 5 parties. Now, let's kindly see on page 86 and 87 that this was signed in wake of Oilfield Act of 1948, where the oil exploration as a policy was to be given to the operators. And if on 87 clause 7, my lords may kindly see, the government desires that the petroleum resources that may exist in the contract area be exploited and discovered with the utmost expedition in the overall interest of India in accordance with the good international petroleum practices. This was the basis. Then let us kindly see that one of the requirement here was that the page 117, Article 6 is 116. 117 mandates that the companies sign the operation agreement. So the operation agreement was one of the aspect, but this was all subject to the principal agreement, which is at page 117. And one more aspect was the at.
No. Where is it provided that the production agreement will prevail over the other agreement?
Yes, Malas, I'll just straight come to that. Malas, the joint operation agreement is at page 353. I'll come straight to that. Malas. Yeah. Well, the agreement starts from page 358. In volume 2 minutes. Kindly see 358 for a minute, fellas. And the relevant clause is at page 368.
It begins at 353.
Yes, the 58, fellas. 358 it begins at. And if my lords can kindly come to specific clause, which is at 368, article 1.43, fellas. which is at page 368, Malas. 368, Malas. 368. Volume 2, Malas. Yes, Malas. 1.43, I'll read, Malas. In case of any conflict of any term of this agreement, with that of the contract, and contract is well as the defined term, and that contract is a principal contract. Well, can take it. Then the provision of the contract shall prevail, which is the production sharing contract. One more aspect on next page, Wallace. 369 is the scope of this agreement.
And in this agreement, the state is provided Kuala Lumpur.
In this agreement is provided Kuala Lumpur, whereas the contract agreement now post amendment, any transaction post 2019 is New Delhi, which is admitted position, which is not disputed. So the first is in event of a conflict between this, the contract will prevail, which means the New Delhi is going to be the seat of arbitration. That's the to see this 1.43. And everything is Indian law, asset is Indian asset, applicable law is Indian law. Now kindly see on page 369 for a minute, Malas, the scope and purpose of this agreement, because this was very, very limited purpose. Clause 2.2 on page 369, Malas. The scope and purpose of the joint operations are limited to the prospecting, exploring, and drilling of petroleum, the developing and operating of, and the producing of petroleum from the contract area. Contract area is defined, Malas. Treating and field processing, and the transporting of petroleum produced under this agreement to the delivery point, and appropriate supporting activities for any of the foregoings.
And what is the scope and purpose of the production agreement?
Yeah, production agreement is well as the entire oil field, anywhere it is to be developed under the contract, because the contract area is defined. All terms inter se parties. The management committee is formed here. Only operational committee is formed. Management committee has the participation of the 3 government representatives in that, which can decide and determine the participating interest is to be changed in whatever proportion, depending on the circumstances arising of production sharing contract. Today, the sole issue which is arising in this case, which has become a dispute, is that in a particular oil field where a new development plan has come up, if I have agreed or not agreed to participate in that by giving my respective percentage of expenditure on that, can you today say that your participation interest will vary and we will redistribute among ourselves without even looking at the production sharing contract? 1. 2. Second is that when the development plan has been approved by the management committee under the production sharing contract, which has been approved by them, which mandates that the production sharing, the development agreement should be brought in force within 90 days period, which has effectively not.
Yes, Mr. Rodgi, what do you have to say about this?
In absence of the mother agreement, this cannot proceed.
With great respect, Milord, my friend is completely wrong. Now just give me 2 minutes. There are two agreements, Milord. One is the production sharing agreement. Please note, it's called the PSC. The PSC, Milord, is between Government of India on the one hand, because Government of India is the sovereign owner of all oil fields in India. So in the PSC, Milord, you have Government of India on one hand, and Milord, the parties who will explore are on the other hand. So the contracting parties, Milord, are 4 on one side.
So, one is the President of India.
Correct. And
one is the ONGC.
So
and the 3 others are the contracting parties, private parties.
all 4, including ONGC, are on one side. Government of India is on one side. Now, we are not concerned with the PSC. We are concerned with an agreement called JOA, Joint Operating Agreement, which is only between 4 of us, nothing to do with Government of India. Inter-sea between the contract explorers is called the JOA. In the JOA, there is an arbitration clause. I invoke that clause. He has accepted that clause. He has argued everything without showing, Milord, that he has accepted. Now, turn to Milord, volume 2 for a second.
Is it new in this court?
Sorry?
Is it new in this court?
Lord, but just have a look now. Lord, with great respect, Lord, he should have shown that instead of going all over the place. Turn to volume 2 for a second. Volume 2, Milord.
Yes.
See now, Milord, only 2 documents. Milord, page 538 is my invocation.
Volume 3 hoga.
Volume 2, Milord.
Volume 2, Milord.
Volume 2. Annexure P4. Your Lordship will find this is dated 19th June. Does my Lord Chief Justice have it? Both the other Lordships. 19 June 2025. This is, my Lord, addressed by our lawyer to Mr. Balbir's client, Hindustan Oil Exploration, on behalf of the other 3. Please note the subject, my Lord, notice invoking arbitration under 17.3 of the JOA. Please mark this and see the first para. We write on behalf of instructions of our clients Hardy, then ONGC, and then Invenair. Your Lordship, remember there were 4 parties on one side and Government of India on the other one. We are not concerned with Government of India. So all the 3 are writing, my Lord, to Mr. Balbir's client because, my Lord, he has walked out. So for whatever it is. So all 3 against him are total 4. We invoke, my Lord, arbitration under 17.3. That, my Lord, your Lordship will find at page 547.
I'll request Mr. Rodgi.
Paragraph 31.
I request it can read 541 also, just for continuation purposes.
If you don't mind. It's not important.
Para 13, 541.
Please turn to 547. In para 31, in view of the consenting parties, we hereby invoke clause 17 of the JOA to refer disputes and differences to arbitration as there is no other alternative, etc., etc. So 17.1, 2, and then 3. 17.3, my Lord, unresolved disputes will go to 17.3. Now see 17.4. The arbitral tribunal will be of 3 arbitrators. Each party to the dispute shall appoint 1, and 2 arbitrators appointed shall appoint the 3rd. Now, my Lord, if the 3rd can't be appointed, 17.5 is important. Any party may, after appointment of arbitrator, request the other party to appoint 2nd. If such party fails to appoint an arbitrator on the receipt of so-and-so, 2nd on the request of first party will be appointed by the Secretary General of the Permanent Court of Arbitration, PCA, at The Hague within so-and-so, so-and-so, so-and-so. Now, my Lord, both of us, his answer is at 550. Mr. Balbir's client wrote back to us.
And the venue is the Kuala Lumpur.
Correct now to
17.12.
Yes. Now come to 551. My Lord. This case is not concerned with venue or seat. It is only concerned with appointment of 3rd. Let's make it clear, my Lord. Our case today is not concerned with where it will be. It is only as to who will be the 3rd arbitrator, because parties have not been able to appoint the 3rd person. Turn to 551. We acknowledge receipt of your reference of notice and accept, please mark, we accept the invocation of 17.3 of JOA. We're not concerned with anything else. While we agree dispute, we not see paragraph 3. They appoint Justice Bal Subramaniam in terms of 17.4, which I have shown to your lordships. Now, these two persons, my lord, have not been able to appoint the third. So matter went to PCA, that is, my lord, Hague. And then there is, my lord, an additional documents filed by them. If your lordship will have that for 1 second, yes. Now turn, my lord, to. So we are concerned with JOA. We are not concerned with the PSC. Turn to 149. So now, my lord, the Permanent Court of Arbitration at Hague is in receipt of this request.
Mr. Balbir Singh, where do you state in this reply that Article 17.3
Yes,
of so and so is not applicable to the proceedings between two of you?
Yes, Malaz, I must point out. Page 550.
No, your notice reply
Yes,
begins at page 550.
yes, Malaz, yes.
You replied to their notice.
Yes, Malaz.
And in pursuance to their invoking arbitration,
Yes, Malaz.
to appoint ABC as an arbitrator.
Yes. Malaz, kindly see, this was on 24/6 at page 550. Immediately, I responded because we admit that this was an error which was made. 564 at page 564. Kindly see 564. And 12/7/2025.
Lord, you can't jump from one.
No, it's not a question of jump. It's a question of which agreement to prevail.
You can't jump from one agreement to another agreement. The other agreement, Lord, nobody has invoked.
Kindly see page 56. I'm coming to specifically to this answer, my lord's question. 565 para 3, Malaz. Rather 2 it starts from. By extension agreement of 7 September 2020, the production I'm sorry, 565 para 2, Malaz. By an extension agreement dated 7 September 2020, the production sharing contract was renewed for.
Suppose if as per the production sharing agreement,
Yes, Malaz.
if there is dispute between the Union of India on one hand
Yes, Malaz.
and any of you on the other hand,
Yes.
any four of you,
Please, Malaz.
then that will